Okay, welcome and thanks very much for joining us to the latest in our Research in Focus discussions here in the School of Political Science and International Studies at the University of Queensland. I'm joined today by my friend and colleague, Professor Kath Gelber, who is a Professor in Public Policy and an ARC Future Fellow here in the school. Today's Research in Focus discussion is a little bit unusual in the sense that to date we've focused on recently published work, but today we're actually focusing on a forthcoming piece, in large part because in late last week the government announced that in coming days it would introduce legislation to repeal a section of the Racial Discrimination Act that Conservative journalist Andrew Bolt was found guilty of breaching in 2011, and it's the public response to that breach in 2011 that is the subject of Kath's paper, co-authored with Luke McNamara. And that article is forthcoming in the very next edition of Australian Journal of Political Science and International Studies, and is titled "The Bolt Case and Its Aftermath, Freedom of Speech and Racial Vilification in the Public Discourse in Australia." Kath, thanks very much for joining me. How did you come to write this article?
This article is part of a larger piece. Luke and I have had an ARC discovery project for a few years looking at the impact of hate speech laws on public discourse more broadly in Australia. And it's been a large project that's used data from a range of sources to try and figure out whether Australia, which now has 25 years experience with racial anti-vilification laws, whether those laws have been effective in changing the nature of public discourse. As we were conducting that project, the Bolt case was handed down, the judgment was handed down, and of course we were struck by this as a paradigmatic case of racial vilification laws in operation. We were both impressed by the judgment itself, which was a very careful analysis of the activities undertaken by Andrew Bolt, but we were also perhaps not so surprised by the subsequent public discussion that emerged from the case. So it struck us that we couldn't be engaged in a large-scale project around racial vilification in Australia without seeking to make a commentary on the Bolt case, and that's what this article tries to do.
So the Andrew Bolt actually was found to be in breach of the Racial Vilification Act on the basis that he had questioned the Aboriginality of people with lighter coloured skin. And this was, you noted both in the paper and in an earlier piece in 2011 that one of the interesting things about the Andrew Bolt case and about the legislation generally is that it has within it the potential that the higher profile the speaker is who is found in breach or who breaches that, the less likely it is that pursuing them through that particular legislation will be productive in terms of what the desired outcome. Can you take us through that argument a little bit?
I will, but I'll just precede it by responding to what you said. First, Andrew Bolt was found guilty of breaching the Act, but not just because he discussed the issue of people with a relatively light skin colour identifying as Indigenous. In fact, it was one of the very important points that Justice Bromberg made in the federal court was that this ruling shouldn't be seen as seeking to shut down public debate on generally on the issue of skin colour and Aboriginal identity. He found that Andrew Bolt had contravened the legislation specifically because he had imputed that the people had deliberately chosen an Aboriginal identity when that really wasn't the most likely one available to them, and that they had done that for personal gain. And so he chose to focus on their race in order to make comments which were derogatory towards the individuals. And further, Justice Bromberg found that the exemptions in the legislation, normally there are exemptions for fair comment on matters of public debate, but he specifically found that Andrew Bolt couldn't claim the exemption on fair reporting or fair comment because he had deliberately used inflammatory language, and essentially because it was poor journalism. There were known errors of fact, or errors of fact in the articles that Andrew Bolt should have known were wrong, and he could have found out extremely easily through a Google search were wrong. So the fact that he included errors of fact and he included inflammatory language and he imputed that these people had deliberately chosen an Aboriginal identity over others that were available to them and that he implied were more likely candidates for their identity, that combination is what amounted to vilification. So in 2011, in my book Speech Matters, I wrote that taking cases like this against high-profile people ran a lot of risks, and I guess I was talking there about the broader critique that legislation like this provides a platform for so-called free speech martyrs. So Andrew Bolt was able to position himself, and after the judgment came down, he did this very consciously, as himself having been the victim of a human rights abuse, that he had been silenced, that he had been victimised, and that all he was trying to do was do his work as a journalist. And I think this is, when you combine that, the public profile, so access to media, access to coverage, with a recalcitrant person, an individual who themselves is not likely to be amenable to the change of behaviour that the law seeks, then you run those kind of risks. So the law generally intends not to punish people, that's why it's a civil law, not a criminal law. It intends to try and encourage people to change their behaviour. So in the best case scenario in this kind of legislation, someone will lodge a complaint against somebody else. The Australian Human Rights Commission will receive the complaint, and then they'll mediate a resolution between the parties, which in the best case scenario will involve a person saying, well, I'm sorry, I actually didn't realise that what I said was unacceptable, and I'll stop, I won't do that anymore. And that's what you really want. The legislation's designed to be educative. But when you have a recalcitrant, high-profile figure, they're very unlikely to be willing to change their behaviour, and so instead they can use it as a platform for positioning themselves as a victim of a breach of human rights.
It's significant that when announcing the repeal of the legislation, or the intention to introduce the bill to repeal legislation recently, the government had made specific reference to this case, saying that we wanted to correct, to reaffirm the central commitment to freedom of speech. Do you think they're right that this particular case is really important in terms of illustrating the importance of free speech from their point of view? Is that...
Well, it's a particular view of freedom of speech. You might call it a libertarian view of free speech that George Brandis and Tony Abbott are promoting, but at the same time it's actually a selectively libertarian view of free speech. So yes, when the Andrew Bolt case judgment was handed down, both Senator Brandis, then in opposition, and then opposition leader Tony Abbott, said that this was a violation of free speech, and that offence, in particular, they said that the use of the word offence in the language of the legislation was just a ridiculous standard to be met for somebody to be found guilty of breaching the Act. And they said offence has no place in legislation. Now what that does is ignores two things. Firstly, it ignores the fact that offence is a word that's used in all kinds of legislation. It's typically used in public order legislation, for example, and we've recently had a free speech case in the High Court that turned on the use of the word offence in the criminal code, so actually it enacts a criminal offence of sending offensive material through the post. So there are lots of other pieces of legislation in Australia that use the word offence that neither Senator Brandis nor Tony Abbott have focused on. They've chosen to focus on the Racial Vilification Act. Secondly, the case law on interpreting the use of the word offence in the Racial Vilification Act is very clear, and it says that the Racial Vilification Act doesn't only apply to language that hurts somebody's feelings or that they feel a sensitivity towards. The way that it's been expressed in the case law is that the conduct has to amount to more than a mere slight. It has to be a significant public incident in order to be considered to be vilification. So both the legislation and the case law have made it very clear that this legislation doesn't just cover somebody whose feelings are hurt. And I think that it's a little bit incorrect for Senator Brandis and Tony Abbott to say that they're libertarians on free speech, when actually their focus here is on overturning the racial vilification laws, not on generally pursuing a libertarian position on free speech in Australian society.
That's interesting. That's interesting. The other dimension to this that's quite significant in terms of the paper, because you focus on public response, the public discourse that emerged after, which is fairly sobering reading, I guess, for those of us who are interested in sort of promoting concern with racial vilification in Australia. Is that something you think the government is tapping into, this broader public discourse? Because you do make the point here that actually it was particular actors who were quite successful in pointing not just Bolt but elements of the conservative media in general who are quite successful in shaping the public debate after the case itself.
They were, and we make it clear in the article that we don't blame the people who lodged the complaint against Andrew Bolt at all. In fact, we admire their decision to pursue a complaint under racial vilification legislation rather than, for example, under defamation laws, because it was much more costly to them in terms of the emotional drain of what was going on, and they received pretty much very little at the end. The only thing that's happened is that Andrew Bolt is required to publish a corrective notice next to the articles. So you can still find the articles online, you can still find the articles as published by the Herald and Weekly Times. All that has happened is that there's a corrective notice published with them now that says these articles breached the Racial Discrimination Act. So they didn't really get much for all of their troubles. So we make it clear we're not blaming the people who lodged the complaint. But yes, it is very true that the way that the discourse that played out in the Australian community after the event, that was in large part instigated by Bolt positing himself as the victim of a human rights abuse. It did several things. We say that firstly, it reinvigorated the long-held debate in Australian political culture about Aboriginal identity and reinvigorated the idea that white people have permission to judge Aboriginal people on how they identify, and that skin colour has something to do with that judgment, and that white people have a valid authority to make a judgment on that. It also mobilised a libertarian, but as I said, selectively libertarian discourse around free speech. And it mobilised a kind of free speech anxiety that I think Brandis and Abbott have very much tapped into. There were other things going on in the Australian community at the same time in the last year or two that also fed into that anxiety. One of them was the proposed media reforms of the previous Gillard government, which in the end were not successful, but were again a launching pad for people to say that this was excessive regulation of speech. And another one was the very ill-advised attempt again by the Gillard government to reform anti-discrimination laws and harmonise them because they're different in every jurisdiction. And as part of that reform, they proposed changing the definition of discrimination so that one definition of discrimination would be to insult or offend somebody on one of the specified grounds, and the specified grounds included political opinion. So this was a really silly proposal by the government, and needless to say, it was very widely commented on in public debate, and I think there was good reason for that. But unfortunately, that good debate fed into this other debate as well. So there were a number of forces at work in the broader community that heightened this free speech anxiety.
Do you think concern over something like the scale of concern and mobilisation around the fear of asylum seekers, that type of thing, does that relate at all to the willingness of the Australian public to think actually yes, political correctness has gone mad in this country?
That's a really interesting question. I suspect that there is a connection. It would be very hard to pin down what that connection actually is. But in the sense that there's an anxiety and a fear that values are under threat, that somehow core values are under threat, then yes, I think that there could well be a connection. In the public discourse post-Bolt, the key refrain has been that the core value of freedom of speech is under threat, and underlying that is a very particular view of freedom of speech. As I already said, it's selective, but it's also a particular view, one that says that the people with the loudest voices, the people with the most access to resources, and the people with the strongest opinions should be allowed to say whatever they want to say, regardless of the consequences or the impact of that speech on other people. And my view is that let's have the public debate. Let's have the debates about asylum seekers. Let's have the debates about freedom of speech. No one's saying, and the Bolt case didn't say you can't have these debates. What the Bolt case said is that if you couch those debates in discriminatory messages towards marginalised, vulnerable communities, that's not okay. You can have the debate, but don't have the debate by vilifying people. Just have the debate. Let's have debates about asylum seekers and other public policy. That's, to me, what the outcome of the Bolt case should have been. Unfortunately, that's not what's been heard.
So one final question, I guess, given you're as probably well placed to speak about this as anyone in the country, the future of the relationship between freedom of speech and hate speech in Australia, I guess not least under this government, but where do you see it tracking?
Well, Senator Brandis has now announced that in the first week of sitting of the newly elected Parliament, which is this week, He's going to introduce legislation to repeal the racial vilification provisions in the Federal Racial Discrimination Act. I don't know how that will go through Parliament. That's a little bit difficult to tell. But if that were successful, that would be the first time, to my knowledge, that any country in the world has willingly repealed racial hatred laws, as opposed to having to change them, for example, when a court decided that they were overbroad and had to be struck down. So for a government willingly to overturn that legislation sends a strong signal to the international community. So, and as I said before, also this is a very selective procedure where they're only looking at the term offence in the racial vilification provisions and not in lots of other provisions. I think it would, if it's successful, it would send a really strong message to the community at large that the caring for the vulnerable and caring for the marginalised is not a priority of the government. And I think it would give a sucker to people like Andrew Bolt, who would see that as a green light to engage in public policy in a way that vilifies minorities. And I think that would be a sad day for Australian political culture. It may not get through the Parliament, and perhaps even having introduced it into the Parliament will give us a good opportunity for a big debate. So I would welcome a debate over the next few weeks and months as this legislation seeks to get passage through Parliament over what free speech actually means and why allowing the loudest and those with the most resources to say whatever they want with impunity actually might not be a very sensible way of understanding free speech. I think that that's a debate that I'd like to have. So bring it on.
Fantastic. It feels wrong to end to focus on a piece that's fairly downbeat, given that you're one of the most upbeat and optimistic people I know. But so misrepresentation of your character aside, thanks so much for joining us, Kath. I've been Matt McDonald. This has been another Research in Focus discussion, and we'll see you next time.